You know how it is. Arguments with the HOA. Usually it's about lawn gnomes or the color of your front door. But what happens when things get serious, like really serious, and end up in court? Well, we're about to dive into a real-life legal battle that shows just how critical the tiny, fine-print details in your HOA's rulebook can be.
So let me ask you this. Have you ever wondered, can your HOA just decide to hold meetings in private? And can they hide their legal bills from you, the person who's actually paying them? It's a huge question. And the answer, well, it's not a simple yes or no. It's buried deep in the fine print of the law, which is exactly what we're going to dig into.
Okay, so let's introduce the players. In one corner, we've got the homeowners, John and Debborah Sellers, and in the other corner, their HOA, the Crossings at Willow Creek Property Owners Association. The showdown all went down in Arizona, stretching from 2012 to 2013.
The Sellers came in with two big complaints. And the first one, well, it's a doozy. They accused their HOA of holding secret meetings. Yeah, you heard that right. Let's look at the actual wording from their petition. They said there was a failure to notice and conduct publicly ARC meetings. Now, the ARC, that's the Architectural Review Committee, is a big deal. They're the ones who approve or deny stuff like your new fence or the color you want to paint your house. So the Sellers were basically saying these huge decisions were being made behind closed doors, completely against the law.
And this is really the core of it, right? On one side, you've got the homeowner saying, hey, these ARC meetings aren't public like they're supposed to be. But the HOA, their defense was simple. Yes, they are. We're following the law and nothing is secret. I mean, you've got two completely opposite stories here. So who's telling the truth?
Well, the real story started to come out during the testimony. A couple of HOA board members got up and explained how things actually worked. They said the meetings didn't have a regular schedule, like the first Tuesday of every month. Instead, they just happened as often as necessary, basically whenever a homeowner handed in an application. And the meetings were just held at a committee member's house. The board members swore they'd never, ever turned anyone away who wanted to come. In fact, it sounds like it was a total non-issue. Before this whole lawsuit, only one other homeowner had ever even asked to attend.
Okay, so that was claim number one. Now let's move on to the Sellers' second big complaint. This time, it wasn't about meetings, it was about records. They claimed the HOA was hiding important financial and legal documents. And this is a direct quote from the court docs. The Sellers said the HOA's attorneys flatly refused to supply any records, specifically the invoices from the HOA's own lawyers and any communications they'd had. You can see what they were getting at, right? The homeowners just wanted to see the receipts to know exactly where their dues were going.
So here we go again, another standoff. The homeowners are adamant, you're illegally hiding these records from us. And the HOA is just as firm. Nope, we have a legal right to keep these particular documents private. It's that classic conflict, isn't it? A homeowner's right to know versus the association's right to privacy.
All right, so we've heard both sides of the story. We know the claims, we know the defenses. But at the end of the day, what really matters is, what do the rules say? To figure out how this all ends, we got to look at the actual laws that were on the books.
Okay, first up, let's look at Arizona's open meetings law. It's pretty straightforward. It says that all meetings of the association, the board, and this is the super important part, any regularly scheduled committee meetings have to be open to every single member. Now, I want you to burn those two words into your brain, regularly scheduled. Trust me, they're about to become the star of the show.
All right, next law on the docket, the state's Records Access Law. Now, this one generally says that homeowners have a right to look at the HOA's books. But, and this is a huge but, there's a major exception. An HOA is allowed to withhold records that fall under privileged communication between an attorney for the association and the association. You've probably heard of this before. It's basically attorney-client privilege.
And for the final piece of the puzzle, let's peek inside the HOA's own rule book. Their bylaws literally say that the Architectural Review Committee shall meet from time to time as necessary. That phrasing, from time to time as necessary, sounds an awful lot like what those board members were saying in their testimony, doesn't it? It seems to back up their story perfectly. Okay, the stage is officially set. We've got the homeowner's accusations, the HOA's defense, and we've looked at the specific state laws and the HOA's own bylaws. So the million-dollar question is, after hearing everything, what did the judge decide?
But wait, before I just give you the verdict, it's super important to understand how a judge even makes this kind of decision. The Sellers, since they're the ones making the complaint, had what's called the burden of proof.
They had to prove their case by a preponderance of the evidence. That sounds complicated, but it just means they had to convince the judge that their side of the story was more likely true than not. Think of it like tipping a scale just slightly in their favor. 51% would do it.
So let's get right to it. On that first claim, the one about the secret A.R.S meetings, the judge's ruling was crystal clear. The petition was dismissed, thrown out.
Okay, but why? That's the important part. And the judge's official conclusion lays it all out. The testimony from the board was credible. It proved the meetings only happened as necessary. That means they were not regularly scheduled. And remember that key phrase from the law? The Arizona Open Meetings Law only applies to regularly scheduled meetings. So, since these meetings didn't fit that description, the law just didn't apply. Simple as that.
All right, so what happened with this second claim, the one about getting a hold of those legal records and bills? Well, you might see a pattern here. That petition was also dismissed.
And the reason why was just as straightforward. The judge found that the HOA was totally justified in saying no. Why? Because those specific documents they wanted, the lawyer's invoices and their private communications, were textbook examples of material protected by attorney-client privilege. That exception in the state law gave the HOA a perfectly legal reason to keep them confidential. So, at the end of the day, both of the homeowners' petitions got thrown out. But look, the big lesson here isn't really about who won or who lost. It's about why it all played out this way. And it really all boiled down to a few tiny details. Think about it. This whole case, which probably caused a ton of stress and took months to get through, was decided by just a couple of key phrases. First, regularly scheduled. Because the A.R.S meetings weren't on a fixed, recurring schedule, the open meetings law didn't even come into play. And second, privileged communication. That little exception in the law was like a legal shield, and it protected the HOA's communications with their attorney.
And that was pretty much it. The case was closed. On February 28, 2013, the judge's decision was certified, making it final. The legal battle was officially over.
And that really brings us to the big takeaway. This whole story is such a powerful reminder that when you get into a legal fight, your feelings about what seems fair or unfair don't matter as much as the precise, exact wording of the rules. So that leaves me with one final question for you. Do you really know the exact wording in your HOA's bylaws and in your state's laws? Because, as we just saw, those little details, they can make all the difference in the world.